see if somebody else is doing it? No.
We'll worry about that in a minute. Okay, ladies and gentlemen, we're going to go ahead and I'm going to call this meeting of the Juvenile Justice Committee to order. Is Senator Brass here? Sorry, I have my glasses on. I can't, you're all a blur. You're all a beautiful blur. So I can't see anything. Okay, he is on his way, but in the interim, we're going to go ahead and hear from Senator Tillery. Welcome, Senator Tillery. There you go.
Thank you so much, Chair Lady Ballinger. And also, if you don't mind, when Senator Brass gets here, if you don't mind telling him you called on him first, it helps his ego.
Okay. Will do. He is Chair of Rules.
He will love the fact that you said that. Senate Bill 376, it's LC 570073S as passed by the Senate. I tell you that LC number because there were several iterations of it, and I think there was a change at the Senate committee that we'll talk about too. The bill started out as something that just I watched happen. I realized that in certain proceedings, it seemed that there was a incongruency as to whether or not judges felt that they had the ability to terminate parental rights or move for a termination of parental rights when parents were moving along the case plan. So, for instance, you may have 4 or 5 different things that you were told you had to do. You may have to have a job. You may have to pass a drug screening. You may have to do this as well and meet your visitation rights, etc. It seemed like in some cases judges felt that if you were moving along one of those things, that they had to find you were moving along your case plan. Whereas other judges felt that if you were moving along one but not all of those things, that they could find you weren't meeting your case plan and then move for termination of parental rights. I think what we mean, what we would like to see as the legislature is we think you ought to be moving on all of those, maybe at different speeds, but simply showing up for visits doesn't mean you're also meeting your drug screening requirements, doesn't mean you're also looking for suitable housing or fixing housing so that the child can come live back with you, etc. So what this bill does in its simplest form is makes it clear that you should make findings on all of those points, and that if someone's just meeting their case plan by showing up to visits, it doesn't mean that they also are meeting their case plan for the other items that would lead to continued reunification. So to do that, what we did on line 40 is added in that when making the determinations and findings, one of the things that the court will look at is whether the parent has made substantial progress towards the completion of the case plan. Adding that word, those words, substantial progress, we think helps prove that we're not just talking about just one point. It's not just progress on the case plan, which again, just showing up for a visit could be. It's slightly more than that. To do that, we had to make some changes also at lines 59 through 61 that say, if the court were to find in a review subsequent to the 75-day initial hearing that there is a lack of substantial progress on the case plan, that within 14 days, DFAC shall develop a plan that allows for either a dual track, is what it's called in most instances, where you're moving towards reunification and possibly termination at the same time, or moving towards termination of parental rights. And why does that matter so much? Well, you can't adopt a child out of the foster care system if there hasn't been a termination of parental rights. Later on in the bill, you'll see at lines 94 and then on lines 119, the exact same language added in two different parts because you had two different hearings. You have a periodic review hearing that language had to go into, and then you have a permanency plan hearing that we had to add that language in. And then we also came in on lines 199 through 204 and said that at some times termination of parental rights may not be in the best interest of the child. And I'm going to paraphrase here, may offend some of our friends at the department. If they are moving to terminate parental rights, one of the things you get asked as a foster parent is if you're willing to adopt that child. And if you're not willing to adopt that child, then they're going to start looking for another family to move them to who will adopt that child. In a foster care setting, maybe that works, but in a setting where you're placed with another family member, if the family member is simply not willing to adopt the child, but is willing for the child to live with them and stay with them, we want that to be an avenue that the department could pick as well. So you'll see on lines 199 through 204, we say that if the child is being cared for by a relative that intends to be the permanent placement, well, in that instance, the department wouldn't have to say, oh, well, you want to adopt them, we got to go look for a new adoptive home. We want to try to provide as much permanency, not the legal term permanency, but as much permanency for the child as we can in a setting that often is not permanent, very stable at all. The last page, lines 238 through 245, those were added at a Senate committee hearing. What had previously been said is that if the department, if we were in one of these situations where we thought that the findings of the court said, hey, look, substantial progress is not being made, we think termination of parental rights should move forward. If the department or the guardian ad litem weren't moving along with terminating parental rights, that the judge could appoint someone for the purpose of starting the termination proceedings. Through discussion with a lot of the advocates and departments and the Office of the Child Advocate, it was determined that that would be better to say not that the judge could appoint someone else to review and see whether or not terminating parental rights would make the most sense, not order someone to file something terminating parental rights. And so those changes in lines 237 through 245 are what you see there. It does not make someone file anything. It just says, hey, look, the judge thinks that this is moving in one direction. Can we take another look and see if maybe parental rights should be terminated? So again, that we could move that child towards permanency. Madam Chair, I think I walked you through all the changes. If there are any questions, I'll try my best to answer them.
Okay, thank you, Chair Tillery. Number 25.
Thank you, Madam Chair. Good morning. I'm good with the bill. I just would need clarity on what is substantial progress. How do you measure that?
We know it's more. Well, let me put it this way: we know it's more than what is required right now. So right now, where the finding could be that it's someone's moving on one plan or one point of a, I'm using a 4-case plan just because 4 seems like an easy number. You're right, Representative, that would be something that the courts would determine as to what substantial is, but it's also a word that we've used quite often when we put in the code that we know it's more than menial progress.
So, if I may, Madam Chair, so let's just say there's a grid with 9 things that must be completed, and I'm asked, that is how it's basically set up for those achievements, and 5 out of 6 would be substantial. Am I understanding correctly?
I can't speak for how the courts are going to interpret that, but I would think that 5 out of 6 would be substantial. I would think 4 out of 6 would be substantial. I think the question would be, though, if we come back after that 75-day hearing or after a 90-day hearing or after a 120-day hearing, if we're sitting at that point in time, that 4 is no longer going to be good enough. We're looking now to see, have you moved to 5 yet?
Gotcha. Okay.
We want to be moving forward, not saying, hey, holding the status quo is so much that our hands are tied by the law and we can't terminate parental rights and move the child towards a permanent setting.
Understood. Thank you.
Thank you. 29.
Thank you, Chairman, for bringing the bill. permanency is so important for these kids, and getting them to a place where they can be adopted out as soon as possible, with giving the parents the opportunity to recover as a parent, I guess. Full support of the bill. I believe that it's we don't ask these parents to do a lot, really, and when kids are removed from their parents, most of the time it's, in my experience, the parents don't get the kids back a lot of the times. And so the sooner we can get to that, the sooner we can pressure these parents to move forward and correct their lifestyle or correct what they're doing wrong for their children. And if they don't do that, the sooner we get them to a home that's loving and is their permanent home. It's so much better for the kids and so much better for the foster parents who are keeping these kids, just for kind of rip the Band-Aid off, just get moving, give these parents a chance, and let's get them to a permanent home. So thank you so much for the bill. Really appreciate it.
Thank you.
All right, thank you. Number one.
Thank you, Madam Chair. This is the follow-up to, I guess, the substantial. In lines 56 and 57, I'm just trying to understand the process. So you have I'm assuming you have an initial review, and then you have a subsequent review. And currently, the way it works is during the initial review, we didn't have the substantial, but then a subsequent review we did. So we're kind of.
No, we didn't have substantial ever.
Well,
Prior to
57
that.
says substantial progress toward the completion of the plan. Is that not the same thing?
Finds that there's a lack of substantial progress towards the completion of the plan. Okay, I see what you're saying.
So
You're saying we're
basically,
adding it
so
earlier on.
substantial. So we had 75 days. They're working on the plan, and then after 75 days, if there's not substantial review because you've had a chance to get started, I guess we're just pushing that up to say at 75. So instead of meeting it here, you have to meet it here.
Yeah, we're saying we want you to be moving along your case plan. Simply meeting one requirement of the case plan is not enough. And I think judges were already finding that in some instances. What we wanted to do is add substantial, and also they knew that this was not something that they weren't locked into a decision simply because a parent was meeting one of the requirements previously.
Okay, and just last follow-up question.
Sure.
So I guess in lines 56, you really won't have a lack of substantial progress towards the completion of the plan of 57 because you never would have made it past line 40. Is that right? Because now you've moved that substantial up, so it's not like you're going to backtrack. We just have to continued substantial review, I guess, continued review.
I'm not sure that
Completion.
I'm tracking with you, Representative, but maybe.
Okay, so right now, you start the plan, I guess, and you say you have to meet 10 things. I'm not sure. I'm throwing those out there.
It depends on the family.
It depends on the family, and this family has to meet 10 things. Right now, after the 75 days on lines 57, after 75 days, you kind of have to be at the 7 mark. What we're saying right now is at the 75-day mark, now we're moving that substantial progress up earlier. So if you've met those 7, you're probably not going to miss the second benchmark. I mean, I'm not having a problem with that. I'm just saying we're moving. Substantial's already in there because that was my initial concern, but it's already obviously there. So we're just moving it up earlier in the
I
process.
think that's a fair way
Okay.
to approach it. Yes, sir.
Okay, all right. Number 19.
Thank you, Madam Chair. Thank you for bringing the bill, Senator. I like the substantial because you could have a list of 10 and 7 of them, one could be mental health exam, one could be drug addiction, evaluation and treatment, and then the others could be more minor things. But if they only get to if they do the majority of the non-minor, of the less important things and miss or don't get to the more important things, then the judge has the discretion to say it's substantial or not substantial. So thank you for bringing this bill.
Okay, all right. Thank you, Representative. And we do have someone signed up, Judge Key. Judge Key, if you wouldn't mind, just go to the podium. If that's just easier. You can come around. It's fine. Or that way, too. Thank you, Judge, for being here.
Thank you and good morning.
Morning.
Let me make it clear first that I'm a juvenile court judge from Troup County, just south of here, 70,000 in the county. I'm here on Jerry Bruce's behalf and on my behalf as co-lead faculty of the Multidisciplinary Child Abuse and Neglect Institute, which we put on around the state. We have put that program on for jurisdictions serving more than 60% of Georgia's children, trying to improve practice in child welfare. And we're excited about this bill because it speaks the same language that we speak when we do this around the state. The 2 points I want to talk to in particular today are the ones you've already talked about some, and that's the at the initial periodic review, which is going to take place normally about 4.5 months from the date the child is removed from the home. That's the point where, under current law, we're required to make a finding as to substantial progress. And if we find that there's a lack of substantial progress towards completion of the case plan, we're required by law to order the department to develop a concurrent plan or a non-reunification plan contemplating a non-reunification plan or a concurrent plan contemplating non-reunification. So when we're 6.5 months into the case, we should be far enough along so that if we're not making substantial progress, and I'll be glad to talk about that some, if we're not making substantial progress, then we've got at least to be, again, seriously considering a plan B. We call it a concurrent plan. We can't wait for months and months and months until we see that we're not going to be able to achieve reunification in a time frame that's consistent with the developmental needs of the child before we go to the concurrent plan. We have to order a concurrent plan. We have to work that plan while still being fully committed to reunification if that still remains the goal. But under current law, there are no time frames for that and no mandated specifically judicial review. So under current law, if I order the department to develop a concurrent plan, say guardianship, say termination, whatever it might be, then I might not, depending on how frequently I review the case, but under the minimum statutory time frames for review, I may not see that case for 2, 3, 4 months again. So I don't know where we are. I don't know what's happening with it. There's also no time frame within which the department's required to file that concurrent plan and begin working that plan. So this bill includes both. Number one, that the plan be filed within 15 days, and then it be reviewed by the court within 45 days. For those courts, and most of our courts do this, that do more frequent reviews than required by law, then that's going to about fit the time frame for the next hearing, pretty close anyway. So we're not adding a lot of hearings in many jurisdictions, but then we're actually looking both at the concurrent plan and the plan for unification. So we're very excited about that piece of it. The other one is the 1522. I'm one of the few judges probably on the bench that was on the bench in November 1997 when the Adoption Safe Family Act was enacted as a federal law that created this 1522 requirement. And the idea is when a child's been in care for 15 out of the last 22 months, and most of these times it's 15 months in a row. Occasionally a child will exit care and re-enter. It's time to fish or cut bait, all right? And so the department's required by law to file a petition to terminate parental rights unless, and there are 3 exceptions to that. And Georgia did a really good job of defining those exceptions. Federal law does not define those exceptions. And the most common one we talk about, one that the senator just talked about, different chairman here, sorry, just talked about was when the child's with a relative is intended to be the permanent placement. So there's some sense of relational permanency at least, though maybe not legal permanency at that point in time. The third exception is if the department hasn't provided services, it would be unjust for us to order them to file a TPR. The most common exception is compelling reasons. So if there's a compelling reason at that point why the department should not be required to file a petition to terminate parental rights, then they're not required to. Kind of the issue around that and what we teach at MD County is that there really should be judicial oversight of that decision. And I would tell you that federal law contemplated that. Under Georgia law, again, doing a very good job of defining those compelling reasons, the only time a judge would be required to be involved in that process is if we have a child who's 14 and older that does not want to be adopted, and that's what's holding it up. And the judge is required in those circumstances to consult with that child in those cases. Otherwise, the court has no review by statute. So this bill creates that review. So the department determines they do or do not have a compelling reason, and at that time frame, we kind of say grace over that. Now, we've been doing this in our county, both of these pieces, very diligently for about 3 years now. And we've significantly safely reduced the number of kids in care, in large part because of these additional reviews, the additional really good work that department's doing around the 1522 and the other provision. And the department likes it. The Troup County Department of Family and Children likes it because they have cover. The judge has made a finding as to, yes, we have a compelling reason. An example would be, there's a more appropriate permanency plan, so we're moving towards guardianship. So why would we file a TPR? Another exception would be the parents are making progress and we can articulate a date when permanency can be achieved through reunification. So these are the two pieces I'm here specifically to speak in favor of on Jerry's behalf, and again to say this is what we teach as part of MD County around the state. I know there's some other ideas floating around 376. I have no idea if they've got any traction anywhere or not, and if they're out there, I can speak to those as well. But those are the two main points I want to speak to, Madam Chairman.
Okay, all right, I appreciate it. Members of the committee, does anybody have any questions for Judge Key? Seeing none, thank you.
Thank you.
Oh, no, hold on, if you'll just wait right there. Number 11?
Sorry, I may have missed this. Who is Jerry?
Jerry Bruce is the Director of the Office of Child Advocate. He couldn't be here today. All right. Thank you.
Okay, thank you, Judge, we appreciate it.
Madam Chair, if I ever have a bill again in your committee, I'm just going to let Judge Key start. Seems like that will probably save y'all some time. So, he is extremely well versed in this area of law. It's been very helpful on a lot of things we're working on.
Yeah, I think that historical perspective too, kind of watching the evolution of, the law and how it's gotten better, is really uplifting, because sometimes seeing the light at the end of the tunnel is I think essential. Members of the committee, any more questions for the author? Seeing none, what is the will of the committee? Several motions do pass. Is there a second? Several seconds. All those in favor, please signify by saying aye. Any opposed? Okay. Thank you, Senator. We appreciate it.
Representative Gullett is going to be carrying the bill.
Okay. We appreciate it. Thank you. All right. I see Senator Brass has joined us. You were called first, Senator Brass, but unfortunately, we had to skip over you. So
Not a problem, Madam
you're
Chair.
presenting Senate Bill 230?
Yes, ma'am, and sorry I can't be in 8 places at one time, so thank you for indulging me here. Okay, so Senate Bill 230, which I think we had a hearing on it last year and did some, been working with you on this bill a little bit on the off season, but I'll just kind of give you a high level and then get into it a little bit. But really, this is the Foster Parent Bill of Rights was passed almost 20 years ago. And so what this bill is doing is updating and strengthening the law, and it expands it to other caregivers of children in DFACS custody and clarifies that foster parents can seek advice and assistance from attorneys and certified volunteer advocates if they have concerns about fostering or about a child in their care. And so if you get into it, lines 19 and 20 is simply defining what a certified volunteer advocate is, and that's as an individual who's been vetted and approved to be such by the Office of the Child Advocate. Lines 12 through 13, and then again on 21 and 29, defines a foster parent to include foster parents, fictive kin, and relative caregivers who are providing care to a child in the custody of DFACS. Lines 50 through 52, it's adding to the Bill of Rights that the ability of caregivers to use the reasonable and prudent parenting standard as current law requires elsewhere in the code. Lines 130 through 138 requires DFACS to develop a better procedure for addressing situations in which a foster parent is alleged to have violated policy or neglected a foster child. And DFACS must give the foster parent appropriate due process, including mediation and or an administrative review, and can have a volunteer advocate present during any investigation. Lines 139 through 144 creates more flexibility in who can assist foster parents if they have a grievance with the department, or need assistance in meetings regarding the child or are excused of violating policy. Under this part, a certified volunteer advocate can be a support person for the foster parent or the caregiver in those meetings and is bound by confidentiality. Lines 147 through 148 clarify that a foster parent can seek and obtain independent legal advice. at their own expense. And then lines 145 and 146 prohibits discrimination or retaliation against foster parents who file a complaint or grievance with the department. 157 through 160, and again on 172 through 177, expands the ability of foster parent advocacy organizations to assist DFACs in creating and reviewing the policies created pursuant to this law. And again, the overall goal here, we're not trying to add legal rights, but what we are doing is allowing them to work in better conjunction with the department, essentially recognizing foster parents as a vital member of the team. And what we've seen in our state over the last 5 years is a significant decrease in foster homes. In 2019, we had 7,510 foster homes registered in the state of Georgia. Today, or in 2023, that number declined down to 4,559. Now, part of that is we do have a decrease in number of foster children in our system, which is great, but we do have to ensure that we have good homes for these kids to be temporarily housed. So that is the ultimate goal here. Florida has done some measures very similar to this. And by comparison, they had 5,442 homes in 2019, and in 2023 now have 8,712. So you can see they had over 3,000 home increase in that same amount of time that we had a almost 3,000 decrease. So that's the ultimate goal here.
Okay, all right. You have several questions. Number 11.
Thank you, Madam Chair. On line 160 and 176, is that meant to be 2024 as opposed to 2023, or am I reading it wrong?
Yeah, it would most likely need to be updated.
Okay.
This bill passed out of the Senate last year.
Okay, thank you.
All right. Well, somebody dropped off. 26.
Thank you, Madam Chair. Thank you for your work on this. I just had a quick question. Do you know the numbers? And if I missed it, I apologize. But do you know the numbers? You said that there was a decrease in the number of homes we have, but do you know what that number of the children that has decreased?
I think we're just north of 10,000, and I know when I came in 2017, I think we were around close to 15,000. And so we're somewhere between 10,000 and 11,000. Is that right, Madam Chair? You probably.
I believe so, yes.
And so over 8 years, we have seen a decrease in foster children by about 5,000. I think those numbers, I don't have those figures in front of me, but that gives you a rough estimate.
And then just one further question. So I've had families come to me before, and I think that they do talk about the difficulties. Is that what was brought to you, that they feel like they're out there kind of alone? What was brought to you that?
That's a big part of it. So back, I want to rewind back to 2019 when we passed one of the first foster care bills that had been passed in a long time, and I think that number was SB 367, and it gave foster parents more standing in permanency cases. And that was really exactly what you said. They just felt like the state wasn't there to support them as much as we could. And so through the years, that bill, in my opinion, kind of helped spur a movement around here. And the governor certainly jumped in and has helped take the lead. The lieutenant governor is doing the same, and the House has been doing the same. We all recognize this in a bipartisan way, that it needs attention. We've got to make the system better, and I think we are all rowing in the same direction for the most part. And so yes, I think that's a big part of this. And last year we did. We talk about, building out a bench of eventually, if a child's not going to be an option is not for them to go back into their home that they came out of, eventually you want adoption. And in order to build out the bench for adoption, you've got to build out the bench for foster. And in order to do that, you got to build out respite care. And so we did some measures last year to strengthen respite care, give the department more flexibility on how much length respite care could be provided. So we're doing all these things to really focus on what's in the best interest of the child. And that if the state will stay focused on that, as we as legislators will stay focused on that, and the system as a whole will stay focused on that child, we're going to continue to make this a better system. Thank you.
Okay, all right. Any other questions from the committee? Chairman Press, I did have a question. With regards to the certified volunteer advocate,
Mm-hmm.
I know that it says that they will be approved by the Office of the Child Advocate, and I know that the Office of the Child Advocate is doing a lot of different things, and I don't want to overwhelm them. Would you be amenable to just saying volunteer advocate and just not having a certification process? Or is that something that you feel very strongly about?
I would. I do think I feel like there needs to be some sort of
Ombudsman
vetting
program or something?
Yeah, I mean, I feel like there does. I mean, we require, just for simple respite care, they've got to go through some training and whatnot, and so, and that could be just to do somebody's laundry.
Yeah.
So I think there needs to be some sort of vetting process, because I mean, last thing we want is a child predator or something like that to sign up for this, and if there's no sort of certification, and maybe certified is too strong of a word, but I do feel like there needs to be someone needs to vet these people, at least at a low level, at a minimum.
Yeah, I agree. I agree. And perhaps that's just something we need to revisit later on.
Right, and if I am certainly amenable if the Office of Child Advocacy is not the appropriate place, I'm game for whatever you'd like to do. But
okay.
I feel like there needs to be some sort of vetting.
I agree, but just not wanting to overwhelm. Some people had expressed some concerns.
Agreed. And if we need to change that to wherever, I'm okay. We just need to come up with an agreement on what that needs to be.
Okay, all right. That's why God invented rules, I think,
Yes,
because
sir.
that's why we
Yes,
have
ma'am.
rule subs.
That's right.
Members of the committee, any other questions? Seeing none, what is the will of the committee as regards to Senate Bill 230, LC 339329? Several moves to pass. Is there a second? Several seconds. Representative Gullett, did you have a question?
I'd like to make an amendment
Okay. What is your amendment?
to change line 160 to 2024 and line 176 to 2024.
Okay, there is an amendment to change on line 60 to 2024, strike 2023, and put 2024 in there. And the second amendment?
It
That-
was,
the
yeah,
first
160 and then 176. Same amendment.
And at 176, we would strike 2023 and put in 2024.
Right.
Okay, so there is an amendment on the floor. There's obviously been a move by Representative Gullett. Is there a second? There is a second. All those in favor of the amendment, please signify by saying aye.
Aye.
Any opposed, like sign. Seeing none, the amendment is passed. So we have Senate Bill 230 as amended by the House Committee on Juvenile Justice, LC 339329, but there will be a new LC number generated as a result of the amendment. I'm guessing that was a friendly amendment.
Yes, ma'am.
Okay.
Absolutely.
So there,
All y'all's amendments are friendly.
there's a move to pass and a second as amended. Senate Bill 230, LC 339329. All those in favor of the passage of a do-pass recommendation for Senate Bill 230, please signify by saying aye. Any opposed, like sign. Congratulations, Senator. We appreciate it.
Thank you, Madam Chair. I appreciate it.
Thank you.
You need a
Who-
carrier?
Yes.
Representative Wiedauer had
Okay.
asked to carry this. and
Okay.
If you're okay with that,
That's
it's
cool.
fine with me.
That's cool.
Thank you.
I appreciate it. Thank you.
y'all.
Senator Strickland?
Good morning, Madam Chair.
Good morning.
You ready for me to start?
Yes, sir.
I bring you Senate Bill 454. It looks intense because it is a 96-page bill.
Oh, let me interrupt. Just one quick note for the members of the committee. Members of the committee, you have in front of you a partial copy of the bill has been placed on top of your folders. We do have full copies of the bill here. I do like trees. So there are roughly about 50 pages that look like this that we did not include in your copies. If you would like to see these, then just raise your hand and we'll get a copy out to you. But otherwise, I just like trees and didn't want to kill quite so many. So you have the substantive portions of the bill, but just not the tables.
My staff gave me a funny look when I asked them on the way out the door a minute ago to print this bill for me, so I have the most recent version, and I now know why. I forgot how long it was. I should have left the table off, but thank you. This bill comes from the Georgia Child Support Commission. That is a commission that we set up years ago legislatively that really oversees our child support table and our child support process and calculations in our state. In the legislature, there's actually 2 House members and 2 senators that serve on this. There's me and Senator Emmanuel Jones on my side. On y'all's side, it's Representative Houston Gaines and Leader Chuck Epstration that serves on this. And this, outside of the 4 of us, the Leader Epstration does family law, I do a little family law, but everybody else on the commission are experts when it comes to how to handle child support. Really quickly, and I won't get into too deep unless y'all want me to. Child support is one of those things when you practice in the area of law, I do a little bit of family law myself, where you put someone's gross income into a worksheet, which is that table that is left off of your copy, and it throws numbers back at you. It's all worksheet driven. And then there's certain deviations that may come up when you go to court and start debating what's going to happen with child support in a case. But what this bill is doing, federal law requires us every 4 years as a state to have an economic study done to look at our current table that we have as to how child support is calculated and make updates to that. This is coming from a study that was completed in 2022, and the first thing this bill does is updates that table, which means you are making adjustment for expenses in raising a child based on the economic study, and you're also adjusting the basic child support obligation table from the max of $30,000 to $40,000 a year as well. So there's the big part of this bill is all based on the economic study as to how our table is calculated. The other part deals with those deviations I mentioned to you. There's 2 deviations that are addressed in this bill, and we changed the way we approach this. One is what's called a parenting time deviation, and that is where I look at the presumptive child support amount that comes out and argue that, well, because I'm splitting the time differently with the child between mom and dad, I should pay less or get more child support based on that. When it comes to what's called a parenting time deviation, we are now making that a parenting time adjustment to actually create a formula for that instead. What is happening right now is based on which county I go to, and in a case, I may get a different result as to what it means for a parenting time deviation. You don't have consistency around the state as to how that's being handled. So the commission has worked together to actually codify a formula to deal with parenting time adjustments to make sure it's consistent at every jurisdiction around our state, and it's now formula driven. We are one of 8 states currently that does not have a formula for this. So the bill does that. Second thing is what's called a low income deviation. Again, it's rarely used. The statistics I was told is only 4% of the time does someone get an adjustment based on their low income. And so we're going to create an adjustment instead of a deviation, again, a formula for that to make sure that can be used consistently around our state as well. Otherwise, there's some general cleanup in here in the 96 pages, but that's all this bill is doing. If you want to dive deeper into this, we have some folks from the Child Support Commission here to testify as well if you want to do that, but that's all the bill does.
Okay, all right, I appreciate it. Number 19.
Thank you, Madam Chair. Thank you, Senator. I practice in this area too, so I just have a few questions. So I understand. You said these are yearly numbers, but they're monthly numbers, right?
Correct.
Okay. For parenting time deviation now, we have to write in the reason for the deviation, and if you don't, then you get a red flag and the judge asks you lots of questions.
Right.
Are we going to have to continue to write in the reasons for an adjustment, or is the adjustment now, because it's a formula, we don't have to enumerate why or how we got to that point? Sorry.
This would happen. It was perfectly appropriate for call a lifeline. We have our staff attorney with the commission. here,
Perfect.
Noel.
Hi.
Good morning, everyone.
Good morning.
That's an excellent question, because these are terms of art. When we say an adjustment, to layman, adjustment and deviation seem very similar. But we're moving from a deviation to an adjustment to sort of normalize accounting for parenting time when calculating child support in Georgia. Right now, it's a deviation, and that has to be specifically requested. If it's not even considered. It's wholly discretionary with the judge. And there's been a lot of societal change since these guidelines were first adopted in 2006 and then implemented in 2007. We're seeing the number of families with more substantially equal parenting time, either true 50-50, things like a family whose the children go with mother 1 week, father another week on, week off, it's called by family law attorneys. So making an adjustment normalizes accounting for it in the process of parenting time, of calculating child support.
So it wouldn't require.
Oh, I'm sorry. Yeah, right. Findings of fact. No,
Right.
there would not be specific findings of fact to account for parenting time.
Okay.
All right, anything further,
I
Representative?
have a question for the author. Well,
Okay.
don't go, because.
Probably do a better job than me.
Well, I noticed that in some of the earlier numbers, the amount is going down for child support, the presumptive amount of child support based on the gross income, which but then as the income goes up, the presumptive amount goes up. I'm wondering what was the rationale behind it. I know it's not less expensive to raise kids now than it was, when the child support guidelines were last revised. So can you give me some background as to what went into that decision?
Yes, I just want to clarify, you're talking about the new table.
Yes,
Right.
I'm sorry,
Yes.
the new
Okay.
table. Yes.
So yeah, that's super important. As Senator Strickland was mentioning, once every 4 years, we're required by both federal regulation and Georgia state law to conduct an economic study. And these updated numbers were developed by the economist. She's really the foremost expert in the nation. Her name's Dr. Jane Venor. She's with the Center for Policy Research in Denver. So we had three basic recommendations to consider. And at $5,400 and below, the table does actually reduce child support slightly. But at combined adjusted gross income, so that's really the fairly low end of the table. At that point and above, it raises them dramatically, especially for families with 2 or more children. The bottom line, the short answer is that's where the numbers fell out. These
Okay.
are purely economically driven recommendations, and so that's the dividing line. I can go really into the weeds on it, and it has to do with which methodology you use, economic studies, but the commission met many times on this issue and finally decided to go with this recommendation.
Okay, and I'm happy to geek out with you later. We don't
Sure.
have to subject everybody else here to that.
Anytime.
That's fine. Okay, all right. Number 29.
Thank you. Seems like there's some feedback. Quick question on if someone's I have 2 questions. I'm sorry. First question: if someone's on disability, like 100% disability, say they're a veteran. I see a veteran part on here. I'm trying to read through it fast. 513 is the line where it starts Veteran Affairs Disability. But if they're 100% disabled, their 100% disability does go into play, right, for child support if they have a child.
Yes, it does.
And if they're not a veteran, say they're just on 100% disability for Social Security or whatever, that also goes into effect as far as their pay.
Yes.
Is there anything disability-wise that does not apply to child support that you know of?
Not that I know of.
Okay.
No.
One other question. I get this often in my area is people who child support funding doesn't start until you've worked at a location for a certain amount of time. So, or they don't actually take the money. So child support you're due, it continues to accrue, but if you're not working and to collect it, basically you have to work a certain amount of time before 15 days. I can't remember what the number is, but a certain number of days. And then by the time you get into the cycle, especially if you move to another state, it seems like some people are kind of there's a loophole where they're jumping up, they'll leave a job or they'll self-employ themselves, work for a company for 1 month here, 1 month there, and we kind of can't catch these folks to pay child support. I did some numbers initially and pulled, and I don't have them in front of me, but there is a significant number of people who owe over, $10,000, over $40,000 actually in child support and arrears. Does this help address that in any way as far as like collection of child support, or is this strictly only the calculations that they do to how much child support they're going to pay?
Yes, I was going to say, my niche is very specifically on the calculation of child support, not on enforcement or collection.
Okay.
I do know we have experts here from DHS, specifically the Division of Child Support Services. They routinely do enforcement actions, so they may want to speak to that.
Okay. Does the author know, just by chance?
Yeah, again, the bill doesn't address that.
It's only the calculations, right?
I think
Okay.
maybe talking about how an income deduction order gets put in place. I'm not sure if that's what you're talking about or something with which the next bill actually renames.
Okay.
But or you may be talking about the process for child support enforcement. I don't
That's
know.
right. It is. That's right.
Okay.
That's fine.
Yeah,
I just want to make
outside
sure.
of this, though.
Okay. Thank you.
Okay, all right. 26.
Thank you, Madam Chair. So quick question, this is not my area at all, I will admit. But you talked about gross income, and I was just curious if you could answer, how do tax implications, alimony implications, health insurance, rising costs, basically all of the rising costs, the gross versus the net, how does that impact folks, or is that considered in any way?
Yeah, this is a question we get from actual parents frequently. And so the economist feels it's best handled on the gross level because those are least likely to be manipulated. You're comparing both parents' gross income, not what somebody chooses to put in their 401k or so forth and so on and so forth. So we deal with both parents' gross income. Then there's adjustments made to account for self-employment taxes paid. If one parent is a W-2 wage earner and the other person is self-employed, they may have similar gross incomes, but it's accounted for if one's self-employed. Why we use gross versus net is, again, just to make sure we're, to the extent possible, comparing apples and apples.
All right.
And I'll tell you, there are clients that say that, why are we looking at my gross? But the bill doesn't change that part. It's what we've done as long as I've been practicing. And I don't know if there's a better way of doing it, but I think she's right. Even gross becomes a battle sometimes of what that gross ought to be when somebody's self-employed. And so there's ways to still fight for deviations, as we discussed, within child support. But I think if you were to shift that to net, you would have a whole nother kind of challenge as to how you would calculate child support. But the bill doesn't address that, to be fair.
Okay, thank you.
Also, I just want to follow up. I think you said something about the rising cost of healthcare. So healthcare premiums need to be considered when ordering child support, but thereafter, the parents are required to split uninsured medical expenses either based on their pro rata share of child support or as ordered by the court.
Thank you.
Okay. Any further questions from members of the committee? Seeing none, what is the will of the committee? Okay, there's several motions to pass. Is there a second? Oh, I'm sorry. I believe Attorney Quick wanted to speak to the bill.
I'm sorry, Madam Chair.
So-
I do have a couple of hats I wear on this, and I needed to speak on at least one of those
Okay.
as General Counsel for the Department of Human Services, which includes the Division of Child Support Services. I want to address specifically what the bill does and what the bill does not do. I also serve on the Child Support Commission. It lifts up to you all for at least 3 areas of a policy determination, whether or not a parenting time deviation should become an adjustment, whether or not a low-income deviation should become an adjustment, meaning they become mandatory, that the judge has to calculate, and a decision about these VA benefits. And that's really what I'm here to speak to you about. And in the interest of time, I won't geek out because I've been wrestling around with this since the new guidelines, income share guidelines, came into effect in 2007. And at that time, it was a sea change from gross. It's been gross for a long time, Representative Lott. It was based at that time just on gross, not of the payor, not an income shares model, which went to. And just so you all know, this parenting time deviation that you're dealing with is an important discussion that the Child Support Commission spent a lot of time on, and the legislature could not solve in 2005 and 2006, which is why their Schedule C is blank on the child support guidelines. So there was no parenting time adjustment at that time. So, but back to, I don't, if there's a sub, I don't have it, but I'm looking at lines 514 on the original bill, which is LC 481100, regarding these disability benefits. And so embedded in this aspect of what the Child Support Commission lifts up to you is a case that the department was involved in, DHS versus Coleclaw. And so you see here that what the bill attempts to achieve is to mirror Social Security Title II benefits with the VA disability benefits. But I do want to simply address, though, what I think maybe is a policy determination I'd like you to consider about that, both in the Social Security context about arrearages and VA disability benefits. So the court in Coleclaw, just very briefly, Madam Chair, highlighted this general rule in Georgia, which is that the non-custodial parent has no right to a credit for the voluntary overpayment of child support without the consent of the custodial parent. So that's what this part of the bill struggles with in terms of how to deal with. We know how the benefits, when you make application for a benefit, you also sometimes get a big payment later after some delay for the governmental entity to make a decision about it. So this, again, on lines...
Okay, we are working from a different LC number.
Yeah.
So just be patient with us while we try to find it. Brian is going to come bring you a copy.
It's 3.1 where it talks about disability benefits.
Okay, that's line
Madam
513.
Chair, 513, so we're very close. But if
Okay.
if you look right above that, in existing code, what you'll see is that the law says the final child support amount shall be retained by the non-parent custodian or custodial parent for the child's benefit and shall not be used as a reason for decreasing the final child support amount or reducing arrearages. Now, what I'm here to call to your attention is that this Coleclaw case suggested something different than that. And I appreciate Judge Williford putting it in here verbatim with the VA disability benefits so that you can see that perhaps it should be able to be used to reduce arrearages. And that is in terms of the Coleclaw case here. It says, because the VA disability benefits paid directly to KC exceeded Weaver's arrears, the trial court properly found implicitly that Weaver, in fact, had no arrearage as of the date of the decision, and we affirm its ruling to that effect. So I commend this to you as something that should be corrected, because there's also an older case that deals with the Social Security since the guidelines were enacted, Scarborough versus Scarborough. So from the department's perspective, especially in terms of who we deal with every day in many low-income situations where folks are struggling to pay their child support, when they get these large benefit amounts for the benefit of the child that should have a retroactive effect to the arrearages that may have accumulated during the pendency of the child support order, we feel it's fundamentally unfair that the statute does not allow the application to the arrearage. And so I just lift that up to you for your consideration on behalf of the division, happy to answer any question. There's a policy debate, I guess, to be had about credits, but Georgia law doesn't really favor those future credits for future child support payment. But as to arrearages, there's a fundamental fairness issue there. And
So on 511, I'm sorry to interrupt, but on 511, to address this injustice, shall not would be stricken and may would be inserted.
So shall not be used as a reason for decreasing the final child support amount, period, strike or reducing arrearages at line, what is, I think, 512 or 511 on your sub.
So you would recommend just striking arrearages?
Yes, Your Honor. Yes, Your Honor. I've argued this many times, one way or the other. I think you have to allow the trial court some consideration to determine whether or not that arrearage becomes an asset available for support. I think there's another part of, the short answer is I believe there's another part of the guidelines that deals with that in terms of what the trial court can do with that. So I wouldn't ask you for that. I might get fired because I didn't ask you for that, but I don't.
So 511, just to, and may be used for decreasing the final child support amount, period.
That's correct.
Okay.
And then on lines 537, maybe? I think you're one off of the one I'm working from.
So that might be 536 for us?
No, it's the same.
It's
right?
the same? Okay.
Delete or reducing arrearages.
It's the same. That part didn't change.
So that,
And shall not to may. Okay.
sorry that was not so brief,
Nope.
Madam Chair.
Is that it?
That's it.
Okay. All right. I do apologize for not calling on you earlier. Members of the committee, do you have any questions for Attorney Quick? Number 27. Sorry, if you'll hang with us, someone has a question.
That's me, Madam Chairman.
Yes, Leverett, Chief Deputy Whip. Leverett.
Thank you. So what we would be doing by the proposed amendment is providing that these benefit amounts that are received by a parent for the child could be considered, would not be considered in decreasing the support amount awarded, but they could be applied to a arrearage and thus reduce the arrearage? Or
That is correct.
So in a sense, this is where you get a benefit where there's a retroactive component, you get a big chunk of money, and is that generally paid for the child?
In both these instances, the Title II Social Security benefits, these are on the obligors, now the payer, or whatever we're calling it now in this bill, account in both instances, but paid to the custodial parent for the benefit of the child.
I see. So
Or directly to the child sometimes.
in other words, it's money that would come to the benefit of the child, but because of the obligor's account with whatever that federal agency or whatever benefits they received. So we're just saying that could be credited toward an arrearage, but the fact that it's paid doesn't change the amount of support we ultimately might award that had to be paid over periodic.
That is
on a periodic
correct.
basis.
But that, can I jump in? That would not be true if the shall not's changed to may, though, right?
That is correct.
So that would be, and I just want to say,
So,
I carried this bill for the commission when they worked on this. What I was told is there has been an official position taken on this. It's a policy question that I
It's a
don't
policy
really
question.
have an opinion. It makes sense to me the way she's arguing, to be honest with you.
okay.
But it's not coming from the commission. I'm not sure where they are on the issue. But it was two separate issues. Do we change the shall not to may, which would allow for it to be used for decreasing child support, or do we just strike the reducing arrearages, which would just allow it, as you said, Chairman Leverett said?
My other question, Madam Chairman.
Okay, sure.
Is this considered a friendly amendment by the author?
I believe it's, because you're carrying it for the commission, my sense is that it's just a policy question for the committee to decide.
Okay.
That's true. And I haven't heard, this is the first discussion I've had on this particular issue, so I don't know how other people feel about it, but from a policy standpoint, it's just your call on it.
Thank you. Thank you.
Okay. All right. Thank you. Representative 19.
Hi. I'm a little confused, I'm sorry. I need to understand why we would change it to May. Why would we allow this payment, which is due to the child and maybe due from retroactive, why would we allow it to be used to decrease child support?
So I would say that is for each and every member to decide for him or herself as to whether. And in 2006, this was the decision, it should not. And the Department of Human Services has no position on that.
Madam Chair, I feel like this is a lot to change policy with this particular amendment. I have no problem with the rest of the bill, but I don't know if it's appropriate to deal with this right now.
Okay. All right, number 26.
Thank you, Madam Chair. So again, for clarification, and this goes to the lady's question, I think we are all understanding it a little bit differently. See, I thought we left it to where we would keep the shall not be used as a reason for decreasing the final child support amount, period. And then just remove that we can reduce. So we're going to, it said or reducing, but we're going to allow it to reduce the arrearages.
Well, we're just not forbidding it from reducing arrearages.
Okay, so again, we're going to keep the original shall not be used as a reason for decreasing the
There
final
are two
child
different
support
amendments
amount?
that we're contemplating.
In both places, it has that same language, I
Yes.
believe, yes.
Yes. There's one amendment that would make it custodial parent for the child's benefit and may be used as a reason for decreasing the final child support amount, period, and striking reduces arrearages. The First Amendment is may be used as a reason for decreasing the final child support amount, and the second one is striking or reducing arrearages. So there are two amendments that would be policy questions for the committee to decide.
But in both places?
Yes. Well, we could do one or both. So if we felt like out of the, because there was a lump sum payment, we're just giving more discretion, I think, to the judge. So number 19.
To the author, well, did this come up in the Senate committee?
No, I don't know what I would do if I was in y'all's shoes, to be honest, is I haven't thought about this before. This is the first time I heard this debated. You could leave the bill as it is and have the commission study this. That was one thing mentioned to me, is this was something they were going to look at for next year or whenever, I guess, in the next meetings. So if you don't want to take this action, either action now, it could be something that we ask the Child Support Commission to dive into. So it is not, this is the first discussion that I've had on this.
Thank you.
Okay. All right. Number 18.
Thank you. Just for clarification, I don't think there's been any amendments made. I think there was
No.
a suggestion made, correct?
No, there aren't any amendments. Those are the amendments that would be proposed by members of the committee if, upon contemplation of the policy question, we wanted to make those changes within the bill. Clear as mud. Because the First Amendment, if I may, to the author, we would give, by striking shall not and inserting may, it's my understanding as chair that would just give the judge more discretion, greater discretion, in deciding the final child support amount. It's my understanding that if we strike reducing arrearages, that would be, it shall be used for reducing arrearages. So number 29.
Yes. So since it says shall not today, I'm trying to get my mind around this. Since it says shall not today and we change it to may, that goes from a negative to a slight positive. If we kept the may not in there, would that keep it still as a negative, where the implication is that it's still not a wonderful, idea, but they may do it, versus an affirmation,
Mhm.
of May. That's kind of what I'm thinking.
Yeah,
Seems like a
May-
big policy thing on the fly for me to get
Yeah.
my head around, but
Well, it would just be a policy question, and like I said, it would be permissive language. So it's not a shall. It's
but
not
may
that
not
the
would
judge
still be-
shall.
may not would still imply not the most wonderful idea possibly, but they still
It would
could
still not
possibly
be
do
allowed.
it. I'm
It
guessing
would still be may not.
May not would
Still
still,
wouldn't be able to do it.
yeah,
they may not would not is a shall not.
Accomplished anything.
Okay.
yeah,
Gotcha.
yeah, that would be a shall not.
Lawyers. Thank you.
Lawyer shall may, yeah, or and. What's the difference?
So, all right. Any further questions for the author? Okay. All right. What is the will of the committee with regards to Senate Bill 454? Is there a motion to pass? There's a motion to pass, and one is the second. Are there any amendments? The chair, just for clarity, is going to propose Amendment 1, for lines 511. Again, I'm working from LC 560170S. 511 shall read, we're going to strike shall not and insert may, custodial parent for the child's benefit, and may be used as a reason for decreasing. So that is the First Amendment. Is there a second? Okay, there's a second. All those in favor of inserting may and striking shall not on lines 511, please signify by saying aye. Okay. Any opposed? Okay, there's several opposed, so that amendment fails. The Second Amendment, Amendment 2, would make 512, line 512 would read, the final child support amount, period. So that is the Amendment 2. Again, 5112 would strike or reducing arrearages, and it would read the final child support amount, period. So is there, I'm making a motion, there's a second. All those in favor, please signify by saying aye. Aye. I'm sorry, I don't vote unless there's a tie. All those opposed, please signify by saying no. All right, raise your hand if you are for reducing the arrearages for a lump sum for the payment. If the child receives a lump sum payment, it can be used for reducing arrearages. All those in favor of the amendment, please signify by raising your hand. All right, that's 3-4. All those against? Okay. Amendment fails. So the Third Amendment, I'm not going to belabor the point. 536. Is there anyone in favor of either amendment, 536 and 537, changing? I'm guessing since the amendment failed on 511 and 512, but just for variety's sake, I guess we'll go through the motions. 536 will read parent for the child's benefit and may be used as a reason for decreasing the final. So we're striking shall not and inserting may. Is there a motion? Okay, amendment fails for lack of a motion. Okay, 537, the Fourth Amendment, 537 will read child support amount, period. And we're striking or reducing arrearages. Is there a motion? There is a motion. All those in favor, is there a second? There's a motion and a second. All those in favor of striking or reducing arrearages and having the line 537 read child support amount, period. Please signify by raising your hand. 4. Okay. All those against? Okay. Amendment fails. Attorney Quick, did you have anything further?
No, Madam Chair,
Okay.
I will see what we can do about cleaning up the case law based
Okay.
on what the clear direction if it passes.
Okay. All right. I actually took those amendments out of order. There should have been a motion to pass on the floor. I do apologize. Oh, there was? Okay, sorry. Thank you, Brian, keeping me straight. So there's a motion to pass and a second for as it is, as presented, SB 5454, LC 560170S. All those in favor, please signify by saying aye. All those opposed, like sign. Nope. Okay, you get a do-pass recommendation for your bill.
Thank you.
Thank you.
Representative Gaines is going to carry the bill.
Okay, appreciate it. Thank you.
Thank you. Appreciate all that.
All right, Senator Cowsert, I appreciate your patience.
I'm gonna run to just you. Thank y'all.
Good morning, Madam Chair. I want to thank you for accommodating my schedule. I know you tried to set this down a couple of times before, and it's wild and woolly right now as we're all dealing with the same challenges. This bill will probably be the less complicated of what you've heard this morning on this committee. It's Senate Bill 520. This deals with child support recovery. And all it does is two things. It looks longer than it is because there are so many code sections that deal with child support recovery. We are just aligning state and federal law. This is all in Title 19. Essentially, state law has always used the term income deduction order in various methods of obtaining child support for children. Federal law now uses the term income withholding order. So a vast majority of this bill is just changing the word deduction with withholding to conform our state law with federal law and rules and regulations. That's important because a lot of the enforcement mechanisms are funded by the federal government and their federal programs, so we need to use their nomenclature. There are 4 different areas in Georgia law where we are changing the nomenclature. In sections 5 and 6 of this bill refers to the Child Support Recovery Act. Section 4 of the bill is the Family Support Registry. Section 7 of the bill is the Uniform Interstate Family Support Act, and that's why we're having to go through each of these Georgia laws that deal with child support recovery and change the terminology from deduction to withholding. Section 8 deals with domestic relations cases, divorce cases, where we have income deduction orders that are commonly used, and we're now changing the nomenclature. And that's why it's so long, because we're addressing so many portions, but it's the same change. It is important also to note on page 2, starting on line 29, we have to define income withholding because we have not previously used that term in Georgia statutes. And most importantly, lines 33 to 36 references a federal form created by the Office of Management and Budget for income withholding orders. And that's why we're referencing the form itself. I think you have copies of them in your folder. That is the actual document, and so we have to build that now into Georgia law and codify that form. That sounds so easy. It truly is. There is one other place where there's a reference on line, let me see, we no longer will require these to be signed by a judge. Commonly now you'll have a judge sign an income deduction order. If you look at line 87, it makes it clear that last sentence that an income withholding notice must be provided to the payer to initiate the income withholding. So the way these work is that the person that owes the child support has to sign this form, and then they give that to their employer, basically to give them permission to withhold their pay or deduct the pay and send it to the spouse that is receiving the child support. These are not filed with the court because they contain confidential personal financial information, and they do not have to be signed by or entered into by a judge. It's really between the employee and the employer. Now, the employee may have been ordered by a judge to comply with this and to instruct their employer to withhold pay, but that's what we're doing. I'm happy to answer any questions that you may have. And I have my dial-a-friend here. Regina Quick is, of course, counsel for the department, and she's the true author of the bill, and she just can help me answer any questions that are beyond my abilities.
Okay, all right, number 19.
Thank you, Senator, for bringing this bill. My only question relates to no judge having to sign. Is that just between the employee who now owes and their employer? Or is that or as a petitioner in a domestic relations case, can I just send it directly to the employer?
You could send it directly. You may be doing that because the judge, as part of your final decree, ordered you to pay the child support. But, usually they don't get into the details of how they order you to pay X amount of child support, but do not require it to be withheld from pay.
Right.
So this would be a way to comply with that. I envision this, that you could have that part of the court's final decree to require you to provide them an income withholding notice.
Okay, but a separate income deduction or income withholding order that
No
right
longer
now I
have
would
to
have
have
to
it.
get signed.
Right.
We don't have to sign.
This eliminates that need, makes your life easier.
Thank you for bringing this bill.
And that keeps it, now that we have to use this form, keeps it from being filed with the court and releasing personal information that's confidential as well.
All right, number 27.
Thank you, Madam Chair. So I had one or two of these cases a long time ago. And so my recollection was the way it was set up, which you noted, was that you didn't always trust Jughead to go institute the
Right.
deduction at his employer. And so the court would sign an order that the payee's counsel could send to the employer and say, hey, the court said to take this out of Jughead's pay, take it out. So we're now sort of relying on Jughead, I guess, to take something to his employer, but I guess he's subject to contempt if he doesn't do that.
Yes, he can be ordered to take that to his employer.
Okay, all right. And so that would be the enforcement mechanism, I guess. Okay, thank you.
Okay, all right. Any further questions for members of the committee? For the author, okay, all right. Seeing no further questions, what is the will of the committee? There's several motions to pass. Is there a second? Several seconds. All those in favor of the passage of Senate Bill 520, we are working from LC 570075. All those in favor of the passage of the bill, please signify by saying aye. Any opposed, like sign. Thank you, Chair.
Representative Wiedauer has offered to carry this in the House if you need.
Okay, all right. He's a busy little beaver.
Yeah, he's into the foster care, child support, and looking after children. So
Okay, all right. We appreciate it. Thank you
so much.
We are adjourned.